Hi, this is J. Sai Deepak. I am a senior associate at Sai Krishna and Associates. I have been practicing law for the last 5 years before the High Court of Delhi. The module that I shall be dealing with is intellectual property and competition law. The general assumption when it comes to intellectual property and competition law is that they are at conflict with each other, they are at loggerheads with each other. This has not been my understanding so far, because I see competition law as a limiting factor or as a limiting agent that ensures that intellectual property rights or the exercise of intellectual property rights does not result in market failure. Therefore, I see this as an extension of the conditions or restrictions imposed on intellectual property owners under IP legislations, except for the fact that this is a limitation or a restriction that is imposed outside the IP legislations and in a different legislation. What is also important to understand is that limitations that are imposed on IP rights within each of the IP legislations have a different bearing. They are meant to protect the realm of commons. They are meant to ensure that intellectual property owners do not go to the extent of curbing rights that are otherwise available to third parties or to members of the public. The object of the competition law is to prevent market failure by exercise of IP rights or by abuse of IP rights. Since we speak of abuse of IP rights and anti-competitive practices, it is imperative to have a reference or regard to the framework of Competition Act and its references to intellectual property. The two prominent provisions where intellectual property finds mention under the Competition Act are Section 3.5 and Section 19.4G. Section 3.5 is basically an exception to Section 3, which deals with the aspect of anti-competitive agreements. Section 3.5 says that nothing that an IP owner does with the object or the intent of preventing infringement of his rights and imposes reasonable conditions pursuant to this particular object shall amount to an anti-competitive agreement within the meaning of Section 3. Section 19.4G, on the other hand, basically forms part of those factors that the Competition Commission shall have regard to in its analysis of whether or not a party is in a dominant position in the market. Section 19.4G refers to any monopoly that is granted or that is acquired by way of a statute, which may lend a position of dominance to an enterprise. Since it refers to any statutory monopoly and there is no exemption for IP rights or there is no exclusion of IP monopolies, so to speak, it would be fair to assume that Section 19.4G of the Competition Act is broad enough to encompass within its ambit all forms of intellectual property. Now, this has two different implications altogether. As far as Section 3.5 is concerned, although it is an exclusion or an exemption from the application of Section 3, it is a limited exclusion which permits only reasonable conditions that may be imposed by an IP owner on third parties with the object of preventing infringement. However, if the condition has absolutely no nexus to this object, or even though it may have a nexus to this particular object, the condition may otherwise be reasonable, it would be perfectly legitimate for the Competition Commission to intervene and to prevent the perpetuation of that iniquity and to treat that agreement as an anti-competitive agreement. The point that I am trying to make is simply this. One of the common perceptions is that Section 3.5 completely pulls out exercise of intellectual property from the scope of the Competition Commission's inquiry under Section 3. This is a myth. If one were to pay attention to the language, it is absolutely clear that should the IP owner go beyond the limitation of reasonable conditions and goes beyond the object of preventing infringement and imposes conditions with a view to delay the entry of third parties' products and by default extend his monopoly, it would be legally justifiable and it would be legally permissible for the Competition Commission to take cognizance of this action or this conduct. Similarly, as far as Section 4 is concerned, when the acquisition of an intellectual property gives rise to a position of dominance and the dominance or the position of dominance is exercised or used in such a way so as to cause injury to third parties and injury in a manner that is prescribed under section 4, it would again be permissible for the Competition Commission to intervene. So for instance, if the owner of a patent who has close to 30 to 40% market share by way of acquisition of that particular patent as far as that technology segment is concerned, imposes unfair conditions or resorts to predatory pricing or resorts to bundling or resorts to any other prescribed activity within the meaning of section 4, it is possible for the Competition Commission to treat that conduct as abuse of dominance. One of the arguments that has been presented on a regular basis and that has also been treated as justified is that each of the intellectual property legislation is a self-contained code or is a self-contained legislation, and that inequities that could arise from abuse of intellectual property are taken care of and are addressed by the IP legislations themselves, and therefore Competition Commission or the Competition Act does not have a role to play in curbing these inequities. I respectfully disagree for the good reason that there is no such exclusion of the applicability of Competition Act that finds mention in any of the IP legislations. In stark contrast, the Competition Act has provisions which make it abundantly clear that should there be a conflict with any other legislation or should there be a conflict with any other provision of any other legislation, the Competition Act shall prevail. Therefore, even if there had been an express mention in the IP legislations which prevents the application or excludes the application of Competition Act to each of these IP legislations, the Competition Act would have prevailed thanks to section 60 of the Competition Act that declares for everybody to see the overriding effect of the Competition Act. The one thing that we will also have to address is, apart from the aspect of overriding effect which kicks in the event of a conflict between the Competition Act and any other legislation, what happens when there is no perceived conflict or apparent conflict on the face of it between an IP legislation and the Competition Act? The answer to this lies in section 62 of the Competition Act, because it goes on to say that the Competition Act shall apply and shall be in force in addition to and not in derogation of any other law, which means so long as there is no conflict between the Competition Act and IP legislation, both these legislations will continue to apply on an IP owner. Therefore, if there are a set of restrictions that apply on an IP owner under the IP legislation, and there are a set of restrictions or limitations that apply on an IP owner under the Competition Act, both these restrictions will simultaneously apply and the patentee or any other intellectual property owner shall adhere to both these restrictions simultaneously. So for instance, section 84 of the Patents Act deals with the grant of compulsory licenses and spells out the conditions under which compulsory licenses may be granted. One of the conditions is that it is permissible for a person interested to apply for a compulsory license if the patentee fails to make available the patented invention at a reasonably affordable price to the members of the Indian public. Since it says reasonably affordable, the corresponding provision of the Competition Act which would be relevant for this discussion would be section 4, which deals with the aspect of unfair pricing as a part of abuse of dominance under section 4. Since section 4 of the Competition Act prescribes unfair pricing, and since section 84 of the Patent Act requires the patentee to sell his goods, his patented invention, at a reasonably affordable price, clearly there is no conflict between the two legislations or provisions. In fact, they complement each other. On the one hand, under the Competition Act, a patentee is expected to not sell his products at an unfair price, and on the other hand, under the Patents Act, he is expected to sell his products at a reasonably affordable price. In such a situation, both the Patent Act and the Competition Act continue to apply on the patentee. Had there been a conflict between these two provisions, section 60 of the Competition Act would have ensured that the Competition Act and its requirement would have reigned supreme insofar as a patentee is concerned. Since we are talking about IP legislations, what needs to be pointed out is that apart from the Patents Act, which contains an express provision that prevents imposition of restrictive covenants or anti-competitive agreements on third parties, there is no legislation apart from the Patents Act which contains a similar counterpart, and this is indeed surprising considering that TRIPS flexibilities permits India to incorporate similar provisions within each and every IP legislation as a safeguard to prevent abuse of intellectual property. Now, Section 140 of the Patents Act itself has a historical basis, and it takes its origins, or it takes its source, or it sources itself from from Article 40 of the TRIPS, which again deals with the aspect of restrictive covenants. The question that now arises is, in the event of a license to a patent containing a restrictive covenant within the meaning of Section 140 of the Patents Act, which would be the appropriate authority or the competent authority to take cognizance of that and to take appropriate action? Under the Patents Act, there are three provisions which make references to anti-competitive practices. One would be Section 84, the other would be Section 140, and the other would be Section 90. In all the three provisions, there is a reference to anti-competitive practice, but there is absolutely no clarity on which authority shall declare or adjudge this particular practice as an anti-competitive practice. Importantly, there is no clarification or an express provision in the Patents Act which declares that the controller of patents shall have the right to adjudicate on these issues, or that there is an exclusion of the applicability of the Competition Act insofar as these provisions are concerned. And since there is no similar exclusion of Patents Act from the Competition Act, one could come to the legitimate conclusion that insofar as anti-competitive practices of a patentee is concerned, it shall be the Competition Act and therefore the Competition Commission that shall continue to exercise jurisdiction as far as the practice is concerned. Now, this is important because there is an ongoing debate on conflict of jurisdiction or conflict of powers between the controller of patents and the Competition Commission. It must be understood that as far as the controller of patents is concerned, he is not a market regulator. His role is limited to ensuring that the patentee adheres to the obligations that are imposed on him under the Patents Act and that he fulfills all his obligations. It is true that under Section 83F, one of the obligations is to prevent any kind of abuse of the patent right that is granted to a patentee. However, the mechanism for that is not compulsory license, because all that a compulsory license does is to create an interest in the favor of a person interested, but does not in any way create a punitive deterrence for a patentee or against a patentee to prevent future abuse of the patent right. Why is this important? It cannot be anybody's case that the only consequence of the abuse of a patent right shall be the grant of a compulsory license, and there can be no other punitive consequence or award against the patentee. The consequence of such a proposition would be that abuse of patents and the exercise of patent rights as a whole would be completely outside the purview of the Competition Act, which does not seem to be the intent of the legislature given the breadth of Section 19(4)(g) of the Competition Act, which does not exclude the Patents Act. Similarly, when there is an express reference to intellectual property rights in Section 3, one can fairly assume and logically infer that intellectual property rights, despite local remedies that have been provided for under IP legislations, continue to be within the ambit of the Competition Act the moment they enter the realm of anti-competitive agreements or abuse of dominance. Simply stated, the moment an intellectual property right is exercised in a way that it amounts to an anti-competitive practice or amounts to abuse of dominance under Section 3 and 4 or 3 or 4 respectively, It is the Competition Act that shall exercise jurisdiction over that conduct, and not the controller of patents or the registrar of copyrights or the registrar of trademarks, since none of these registrars or controllers have the power, expertise or wherewithal to deal with the aspect of market consequences of the abuse of intellectual property. Apart from the interplay between IP legislations and intellectual property, the other aspect that has come to fore in the recent years, at least in the last 5 years, is the anti-competitive implications or antitrust implications of exercise of standard essential patents or enforcement of standard essential patents. Standard essential patents, as the name explains, refers to a breed of patents where compliance to a standard is absolutely essential and the patent claims that particular standard. In other words, there is no non-infringing alternative to the patent if a third party wishes to comply with the technology standard. For instance, the GSM technology in the arena of telecommunications has a host of standards and it has a whole bunch of patents, in fact close to 30 to 40,000 patents, which claim each of these technology standards, and each of these patents are held by multiple entities. In other words, there are at least 5 or 6 major players who have distributed among themselves or who hold among themselves a host of 30 to 40,000 patents. The question that this kind of litigation or this kind of holding poses for antitrust jurisprudence is this: since the holding of a standard essential patent or the holding of a host of standard essential patent lends a position of dominance to the patent owner, are there obligations on the patentee or under the competition regime apart from obligations under the Patents Act? The answer is a straightforward yes. This is because, again, standard essential patent, although may be a breed that may be referred to in the realm of commerce, is not something that is specifically recognized under the Indian Patents Act. The Indian Patents Act strikes no distinction between patents and standard essential patents. Therefore, all obligations under all legislations that apply to a normal patent equally apply with equal vigor to standard essential patents. Therefore, the proscription of abuse of a patent right under section 4 of the Competition Act, read with section 19(4)(g) of the Competition Act, applies equally to a standard essential patent, and in fact even more, considering that a position of dominance is better acquired in the case of the ownership of a standard essential patent compared to a normal patent. Now, what are the consequences or what are the aspects of the enforcement of a standard essential patent that have antitrust implications? The first is the manner in which a standard essential patentee is expected to conduct in order to ensure the fair adoption of the standard by all third parties and fair and reasonable access to the technology standard to all third parties. Here it must be pointed out that each of these technology standards are formulated through a consensual mechanism by standard setting organizations. So, for instance, in the arena of telecommunications, it is the European Technology Standards Institute, which is one of the major standard setting organizations whose standards are recognized across Europe and in India by the Department of Telecommunications when it comes to the GSM technology. The point that is to be understood is standard setting organizations limit themselves to setting standards and limit themselves to seeking declarations from their members that if their patents are declared as standard essential patents, then FRAND obligations, that is fair, reasonable and non-discriminatory obligations, will apply to each of their members and to each of the standard essential patentees. However, standard setting organizations do not take upon themselves the duty or the obligation of spelling out what would a FRAND obligation translate to practically with respect to each and every patent held by their members. In other words, price setting or formulation of a methodology is not something that is undertaken by standard setting organizations. Then who undertakes this process or who undertakes this exercise? There are two aspects of the issue. One is price setting or the actual royalty setting, and the second is curbing those aspects which go beyond royalty setting but which still amount to abuse of dominance. Insofar as the broad conduct of a standard essential patentee is concerned, it is outside the purview of a controller of patents simply because the controller of patents has only one mechanism, namely the compulsory licensing mechanism, which restricts itself to 3 conditions or 3 circumstances in which the mechanism may be invoked. However, the nature of the Competition Commission, the scope of the issues that it is capable of addressing, the width of the powers that it has been vested with by the legislature more or less give rise to the conclusion, a firmly reasonable conclusion and a firmly irrefutable conclusion, that the Competition Commission is not only better placed but is also probably the sole authority or the sole forum which has the power to deal with aspects of abuse, since they cannot be dealt with legally by the controller of patents. How does this play out practically in terms of an interactive exercise of authority by the Competition Commission and the controller of patents? When the aspect of abuse of dominance by a standard essential patentee is brought to the attention of the Competition Commission, the Commission has the power to look into to those aspects of the patentee's conduct which amount to abuse within the meaning of Section 4. However, where the issue relates to the aspect of royalty setting, to the extent that the issue relates to actual price fixation, Section 21A of the Competition Act permits the Competition Commission to outsource or farm out royalty setting or price setting to an authority such as the controller of patents, who may in turn invoke the aspect of compulsory licensing under Section 84, subject of course to the satisfaction of conditions under Section 84. In other words, let's take a situation where a patentee chooses to engage in multiple discussions. A standard essential patentee chooses to engage in multiple discussions with multiple third parties on price fixation or on royalty fixation, and does not let each of these parties speak to each other, so that they do not ever know whether each of them has been offered the same or similar set of royalties or similar royalty schedules. In such a situation, if there is an NDA that is imposed on each of these parties by the standard essential patentee which prevents them from talking to each other, it makes it impossible, at least legally, for each of these parties to verify the FRAND compliance of the royalty that has been shared with them by the patentee. Since one of the obligations on a standard essential patentee is to offer non-discriminatory terms to similarly placed parties, the effect of an NDA that prevents the parties from speaking with each other is to prevent them from verifying whether or not they have indeed been offered non-discriminatory terms. Therefore, this aspect of the issue where the patentee creates silos of information and prevents parties from talking to each other typically falls within the realm of abuse of dominance, and this aspect of his conduct is best decided or adjudicated by the Competition Commission and not the controller of patents, because the controller of patents can limit himself to only 3 aspects which have been provided for under Section 84, namely reasonable affordability, access requirements, and any other reasonable requirements of the public. The aspect of using an NDA to prevent flow of information and to use the asymmetry in the information to the advantage of the patentee is not something that can be adjudicated by the controller of patents invoking the compulsory licensing mechanism. Therefore, the best way forward would be for the Competition Commission to take cognizance of those aspects which don't deal with the aspect of price fixation, and to farm out those aspects which relate to price fixation to the controller of patents. However, in doing so, the question that must be again asked is whether the Competition Commission is barred by the Competition Act or the provisions of the Competition Act from setting royalties. In my humble opinion, section 27 and 28 read together, which enumerate the powers of the Competition Commission to deal with situations of anti-competitive agreements and abuse of dominance, abundantly provide for a wide range of powers, including the power to create interest or to create titles in favor of third parties. So, for instance, when one deals with the aspect of abuse of dominance, the Competition Commission has the following powers. One is to divide the abusive entity in such a way that the resultant entities are never in a position to abuse their positions or are never in a dominant position at all. In the alternative, it also has the power to create interest in favor of third parties to ensure that the right which gives rise to a position of dominance to the dominant player is no more within the power of the patentee. So, for instance, if a standard essential patent is the reason for lending a position of dominance to a patentee or to an enterprise, it is within the power of the Competition Commission to create a license in favor of third parties on reasonable terms to prevent the abuse of the patent. In fact, if there are agreements that have already been entered into which are abusive in nature, the Competition Commission also has the power to rewrite the terms of the agreement to prevent future abuse. In light of these broad powers of the Competition Commission, it could be said that in stark contrast to the position taken by antitrust regulators in Europe and the United States, Indian competition regulator, which is the Competition Commission, appears to have the power to set prices as well. The question that could be then asked is whether the Competition Commission has the wherewithal to deal with aspects of price setting. The Competition Commission is inherently positioned or is inherently better placed to deal with aspects of price setting than the controller of patents. Of course, it could be said that the controller of patents probably has the requisite subject matter expertise or the domain expertise to understand the nature of the invention. But be that as it may, nothing stops the Competition Commission from seeking opinions of subject matter experts in understanding the nature of an invention before creating rights in favor of third parties by way of licenses. Now, this is insofar as it relates to conflict of jurisdiction. The other aspect of standard essential patent litigation which has a serious bearing on competition law is the very act of institution of suits of infringement and the very act of seeking exclusionary reliefs by a standard essential patentee against third parties. There is a brilliant paper that has been written by Mark Lemley and by other experts on the subject who have gone on to opine that the very holding of a standard essential patent deprives the patentee of his right to seek exclusionary reliefs against a third party, since any grant of an exclusionary relief in favor of a standard essential patentee and against a defendant would end up creating a serious disparity in negotiating powers between the parties on the issue of royalty fixation and could end up hastening the process or tilting the process in favor of the patentee. This is one of the reasons that courts the world over and competition regulators the world over have frowned upon the grant of interim injunctions or any form of exclusionary relief in a situation which deals with standard essential patent, considering that it has the consequence, or it could have the consequence of completely tilting market conditions in favor of the patentee to the detriment of all third parties. However, this is not an absolute or blanket ban on the grant of on the grant of interlocutory reliefs. The nuanced position that has been taken the world over is this: should the third party demonstrate his blatant and brazen unwillingness to secure a license, despite having been given ample material to satisfy himself on the issues of validity of the patents, on the issues of essentiality of those patents, and after having been offered rates which are reasonable, fair and non-discriminatory, it is certainly within the power of the courts to grant interim injunctions against a defendant. It is certainly within the right of the patentee to seek exclusionary reliefs against such an unwilling licensee. However, the burden of proving that the defendant has been an unwilling licensee lies on the patentee, considering that he holds a monopoly which gives him extensive market power. In stark contrast, in other litigations, one would expect the defendant to be put in a position where he has to show that he has been reasonable. In a situation which concerns a standard essential patent, the obligation is on the patentee who seeks an exclusionary relief to show that he has no other option but to seek exclusionary relief, since the defendant is an unwilling licensee. This is an interesting area that is under development in India, and will hopefully be adjudicated upon in the course of the next few months, considering that there are a lot of standard essential patent litigations that are underway before the Delhi High Court. However, a standard essential patent litigation probably is a good test of the robustness and the flexibility of the competition regime to address several aspects. For instance, it helps us understand whether or not the Competition Commission can comment on the propriety of invocation of statutory reliefs by an intellectual property owner. So, for instance, on one hand you have the argument of the intellectual property owners such as standard essential patentees, who claim that they have the statutory right under individual IP legislations or patent legislations to sue defendants for infringement should the defendant use their technology without their consent. And on the other hand, you have arguments under competition law which say that in the context of a standard essential patent which lends a position of dominance to its owners, the exercise of intellectual property rights or the exercise of statutory reliefs cannot be viewed in isolation and cannot be looked at through the prism of exercise of statutory reliefs alone, considering its significant ramifications or consequences for market players and on other stakeholders, including consumers. The middle path that could be taken is, unless and until there is a demonstration of malafide by the defendants to a reasonable offer by the patentee, it would be unfair and it would be an act of abuse by a patentee to seek exclusionary reliefs, seems to be the right way forward, considering that it does justice to the patentee's right to seek remuneration for the use of his technology, and it also balances the equally compelling interests of the defendant, who says that unless and until he is convinced of the quality of the patent and its relevance to his product, he does not have the need, or he is under no obligation to seek a license. One of the decisions that I would certainly request people to read is the decision of Ringo versus ZTE, which was passed in 2013, or which was pronounced in 2013 by the UK Court of Chancery, the UK Chancery Court. Now, the UK Chancery Court actually took a very nuanced position and accepted the defendant ZTE's position that merely because the defendant chooses to challenge the validity of a patent which has been asserted against him in the context of a standard essential patent litigation, he cannot be treated as an unwilling licensee, because the position that he takes amounts to this: should the patent pass muster on a scrutiny by the court, and should the patent be adjudged as valid, and should the patentee offer a rate which is otherwise fair, reasonable and non-discriminatory, he will have no other option but to take a license. But in the event of the patentee failing on any one of these anvils, there is no obligation on him to seek a license for the patent, merely because the patentee himself has declared that his patent is a standard essential patent. The one important aspect that needs to be explained here is this: Standard setting organizations typically do not take upon themselves the responsibility of adjudicating any claim of essentiality or even the validity of the patent. In which case, apart from the self-serving declaration of a patentee that his patent is a standard essential patent, there is no other way of testing the validity of a patent conclusively other than by challenging its validity before the court of law in a counterclaim for revocation or before the IPAB by way of a revocation petition. Unfortunately, the tendency today appears to be that any challenge to the validity of a patent is treated as a sign of unwillingness on the part of the defendant to seek a license. This, in my humble opinion, would be the incorrect approach to a situation such as this, where there are multiple interests, and it would be unfair to view the litigation purely from the patentee's point of view. One hopes that during the course of the development of jurisprudence on intellectual on standard essential patent litigation and its anti-competitive and its competition implications, we get to understand the nature of intellectual property rights better and the actual scope of enforcement that is permissible within the framework of both IP legislations and competition law. And we also get to understand the scope of the competition law's powers to interfere with statutory rights and remedies, because that has an implication on the power of courts to take cognizance of suits of infringement instituted by standard essential patentees. One hopes that in the next few months we will have a few decisions that shed light on the law on these issues. Thank you.